Hello and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your CPD requirements, and at the end of the podcast we will explain how to get in touch if you wish to claim CPD points or if you have any comments or questions.
Hello and welcome to podcast number 87. In this podcast we're looking at three cases, as always. First is a case from the Upper Tax Tribunal. We don't often do cases from there. But anyway, this looks at the tax treatment of sums paid to an employee in respect to injury to feelings. It has been a bit of a battleground of late. Secondly, we've got recent judicial review of the current criminal records disclosure scheme, stay with me here, and how this applies to accepted employment roles and whether the scheme is in contravention of Article 8 of the European Convention of Human Rights. It's an important point. And finally, we've got an EAT case which looks at the early conciliation process that claimants have to go through before they can bring a claim in the Employment Tribunal, and then the ability of a claimant to add a new respondent into the claim. As always, please remember we do have a YouTube version of this podcast, details of the case names and so on screen during the podcast, and we send out links to the case as well on Twitter at Nicholas Robertson, at Nicholas Robertson, Nicholas ROBER11. That's Nicholas ROBER11, and that's in the podcast is obviously available from the Mayor Brown website too. And finally, at the end of all this, a couple of thoughts on serial and making a murderer, since that seems to be very much a key topic for people at the moment. So, first case, Murthy and HMRC. This is the Upper Tax Tribunal decision I mentioned, and it looks at the treatment of sums paid to an employee under a settlement agreement in respect, allegedly, of injury to feelings. So, quick legal background. Section 401 of the Income Tax, Earnings and Pensions Act 2003, ITEPA, charges income tax on payments received in connection with the termination of a person's employment. So, termination of a person's employment, that's the first point. Under Section 403 of ITEPA, the first 30,000 of such a payment, a termination payment, can be paid tax-free. We all know that. Also, there are a number of exemptions to the Section 401 income tax charge, and one of them is Section 406 ITEPA, which states that Section 401 does not apply to payments made, quote, in connection with the termination of employment by the death of an employee or on account of injury to or disability of an employee. Injury to are the key words. Injury to or disability of an employee. The facts of the case are pretty standard. They involve an employee, Mr. Murthy, who is made redundant from his employer in 2010. He brings a claim at the Employment Tribunal for unfair dismissal and age discrimination in relation to the termination of his employment, and his claim is subsequently settled for £200,000. When it comes to sorting out the tax bill, Mr. Murthy argues the sum is not taxable because it was given to him in respect of his injury to feelings for the alleged age discrimination, and therefore, he says, it falls within Section 406. It was on account of injury to me, my pain and suffering. HMRC, however, take the opposite view and hold that the whole of £200,000 was taxable under Section 1, didn't benefit from the Section 406 exemption, but they did accept that £30,000 was tax-free under Section 403. In fact, they actually offered him a second £30,000 tax relief as part of a deal to settle, but he didn't take it. So, for our purposes, key point, all of the £200,000 is taxable apart from the first £30,000 in the normal way. Well, he was unhappy with the outcome, so he appeals to the first-tier tax tribunal and then the upper tribunal. So, the key issue in this case is whether payments for injury to feelings under discrimination law should benefit from the income tax exemption under Section 406 of ITEPA that refers to payments on account of an injury to an employee. Worth noting that prior to this we've had two EAT cases, Orthet and Timothy Jones, which have both held that compensation for injury to feelings does fall within the exemption to income tax in Section 406. But, bit of background first of all. One point to note is that an award for injury to feelings is often made to an employee if they've been successful in a discrimination claim. Fine. One point to have clear right from the start is that it's not in dispute that a payment in respect of discrimination which is unconnected with the termination of employment. It's not disputed that that is not taxable at all. Section 401 only catches payments made in connection with the termination of employment. So unless you're talking about the termination of employment or the alleged discrimination relates to the termination of employment, Section 401 is not engaged, and this particular case has no application. The upper tribunal upheld the decision of the first tier tax tribunal and found that the sum paid to Mr. Murphy under the settlement agreement in respect, he asserted, of injury to feelings did not benefit from the tax exemption under Section 406. The upper tribunal found that injury in the context of Section 406 does not include a payment for injury to feelings in relation to a termination of employment. Rather, the upper tribunal interpreted injury in this context as being an injury linked with disability, death, or a medical condition leading to the termination of employment. In coming to this decision, the upper tribunal held that the two earlier EAT decisions, the ones I mentioned earlier, Orfett and Timothy Jones, which had come to the opposite decision, were wrongly decided, and they commented that they thought the EAT had very little support for its position that awards for injury to feelings fell within the Section 406 exemption and therefore were not taxable. Well, as a result of this case, we now have conflicting appellant authorities in respect of the position on compensation for injury to feelings paid in connection with the termination of employment. And clearly we hope that a Court of Appeal authority comes along in due course to resolve this, to put the whole thing to rest. But if you step back for it in terms of where the law is at the moment, what's our view? Well, there are clearly two possible ways of looking at this, and I think it's probably fair to say my own views about this, and what is the right answer here, have varied over time. But reading this decision, it is very convincing in its reasoning. I think it's reasonable to take the view that the tax-free payment in Section 406, which refers to a payment on account of injury or disability, is to be read in the context that it's an exception to a tax charge arising on the termination of employment. So I think this decision is quite compelling when it states that the idea of a payment on account of injury means injury leading to the termination of employment, and so is equivalent to death or disability leading to the termination of employment. In that case, an injury to feelings award has a more tenuous connection with the termination of employment. Anyway, I think in the short term, the question is what employers should do about this. My strong view would be that it would be extremely unwise to agree a severance payment where discrimination in connection with the termination of employment is being alleged, and then try and treat a payment for pain and suffering as tax-free. Claimant lawyers are often very keen to do this, but I think it would be very dangerous in view of this decision. Also, if there are indemnities given by the employee, and that's sometimes a tack that's taken by claimant lawyers, that would still leave the employer out of pocket in the short term and having to enforce the indemnity, which may be easier said than done. Clearly, seeking pre-clearance from HMRC is going to produce a decision from them based on the Murphy case. And so I think it'd be a brave employer overall that would take on that particular risk, unless the deal was otherwise so favourable for the employer it was willing to take on the potential additional costs of the tax risk. So that's Murphy and HMRC. Next up is the case of R and the Secretary of State for Justice. A number of our clients have a DBS scheme applicable to them, so a Disclosure and Barring Service Check scheme, which is a scheme for looking at potential criminal records for prospective employees. I think about 4 million people a year in the childcare sector alone have to provide criminal records certificates. So we felt that the recent development in this area of law would be of particular interest. At the heart of the judicial review of the current criminal records disclosure scheme is the scheme's interaction with Article 8 of the European Convention of Human Rights. And the key focus of the court in this review was the exceptions to the disclosure of convictions rule, which provide that in certain circumstances all prior convictions are disclosable, regardless of the nature of the offence or how long ago it was committed. As a quick summary of the law in this area, the Rehabilitation of Offenders Act 1974 provides that convictions will not be disclosable to employers or prospective employers where those convictions are considered spent. However, there's an exception to this, which came through the 1975 Exceptions Order, whereby certain specified professions in employment are required to disclose all criminal records regardless of whether spent or not. The DBS provides details of job applicants' criminal records via either a Criminal Records Certificate, a CRC, or an Enhanced Criminal Records Certificate, an ECRC. An ECRC, just in case you're interested, also includes soft police intelligence that goes beyond just the applicant's criminal records. This exception was amended, however, in 2013 following a particular case, so that a single conviction which didn't lead to a custodial or suspended sentence and wasn't sexual or violent offence was no longer disclosable after 11 years. So single offence that's below a particular level of severity, no longer disclosable after 11 years, and if you were under 18 when it happened, it's no longer disclosable after 5.5 years. However, this is the key bit, if the individual has more than one conviction, this exclusion does not apply, and so all records are disclosable on the CRC or the ECRC, regardless of the time that has passed or the nature of the conviction. It was this point that the applicants disputed in this judicial review, arguing that both the exception and the requirement to disclose all convictions where the individual had more than one conviction is in breach of Article 8 of the ECHR. As a reminder, Article 8 of the ECHR provides the right for respect for one's private and family life, home and correspondence, without undue interference by public authorities, except in certain defined circumstances. Well, let me give you an example of the sort of cases that were being discussed about here, which the court accepted were at the outer margins of these types of cases, but they were real cases. Two claimants, Ms. P and a Mr. A. Ms. A was a teacher who suffered from schizophrenia. During the 3.5 years she'd suffered from the illness, but it had not yet been diagnosed or treated, she was convicted of theft on 2 occasions for shoplifting, stealing a book and a sandwich. She was bailed to appear before the magistrates' courts, but failed to attend the court hearing, so got convicted, with both being noted on criminal records against her. Ms. P has since been applying for voluntary teaching positions and is also looking for paid employment as a teaching assistant. However, she alleges that her disclosable convictions, and they're disclosable because she's subject to the exception rule of lifetime disclosure, where the subject has more than one recorded conviction, they require her to reveal her past mental health issues, and this history prevents her from obtaining employment. Mr. A, who's now 51, had committed 2 minor theft offences at 17 and 18 years old. No subsequent criminal record, but he was still required to disclose these offences as he was caught by the exceptions requirement for lifetime disclosure because he'd got more than one conviction. He was concerned that his family might learn of his previous criminal convictions and that his employment as, wait for it, a finance director and project manager might be jeopardised. I think he might have a point there. Well, the submissions of both applicants seeking judicial review were objections to the scheme as it applied to certain professions, in this instance financial services and teaching professions, which both still require disclosure on a lifetime basis of more than one spent conviction, with no consideration in the scheme of when that offence was committed or the type of offence committed. In the case of both claimants, clearly the offences were minor. They were committed a long time ago and had no relevance to their employment today, they said. Well, Lord Justice McComb thought that there should be some mechanics in place to test the proportionality of the offence in order for the scheme, the disclosure of criminal record scheme, to be in accordance with Article 8. And this was supported by Mrs. Justice Carr, who felt that the legislation failed to meet the requirements as to quality of law. And in those circumstances, considerations such as administrative convenience, which is how the Secretary of State was trying to justify it, they fell away. The single conviction exception to lifetime disclosure was arbitrary and disproportionate, and therefore contrary to Article 8. The opposing view, which has been put forward by the Secretary of State for Justice and the Home Department, was that an individual with just the one conviction could be given a second chance, but not a third chance. They contended that to conduct an independent review on a case-by-case basis would be impractical and an administrative nightmare in view of the number of cases that were likely to require review. But the court disagreed. The application was allowed, with Lord Justice McComb saying it's not justifiable or necessary for any individual to have minor offences disclosed indefinitely from many years ago, merely because there is more than one minor offence. So the court held there was no logical connection between the application of the scheme to ensure suitability for employment and the interference with the claimant's Article 8 rights. So the scheme is going to require further amendment to deal with the decision. And Lord Justice McComb asked that the government make submissions to address these faults in the scheme before the court makes its final order. It's also possible the Secretaries of State for Justice and the Home Department may appeal, and they have indicated they're looking at an appeal. And if they're successful, the issue may yet be resurrected. But employers relying on DBS checks should ensure in the meantime that, subject to any specific sector guidance, they exercise careful, independent judgment in considering what weight to attach to disclosures which relate to old or trivial convictions. Employers should also consider the relevance of convictions to the employment in question, particularly where the conviction is a spent one. As Lord Justice McComb said here in this review, it's important to assess the factual background on a case-by-case basis and to draw a distinction between the nature of the offence, the time elapsed, the disposal by way of sentence or otherwise, and the absence of any independent review of a decision to disclose the offences. Now, the question, I think, in the wake of this case is, where does it actually leave employers? And is there now a legal risk for employers that didn't exist previously? Until the mechanics of disclosure are amended, employers are still going to be given the current level of disclosure when applying for a DBS check, whether it's ordinary or enhanced. Clearly, it's fair and proper for an employer to exercise independent discretion if given information about historic and irrelevant convictions. But what's not clear to me is whether a claimant who was rejected would have a basis for a complaint against a private sector employer. I could anticipate a public sector employer might be found to have breached the Article 8 rights, but at this point it's not really clear to me quite how or whether a similar route exists for a disappointed job applicant to a private sector employer. There's also, of course, the practical point, I think, that it's very difficult for job applicants to know exactly why they have been rejected. It's unlikely that many employers are going to volunteer the information that they were concerned about the existence of prior, historic, irrelevant convictions. So this is probably a case to be aware of, particularly if the disclosure mechanism does introduce some sort of filtering, but not yet. In the meantime, whatever the precise legal obligations, one would certainly hope that employers would exercise a degree of perspective and judgment before rejecting someone with historic and utterly irrelevant convictions. So that's the case of R and the Secretary of State for Justice. Final case, Mist and Derby Community Health Services NHS Trust. This is an EAT decision looking at procedural requirements to bring a claim in the Employment Tribunal. Background? Well, in most instances, before a claim can be brought now in the tribunal, there's a requirement, as we know, for the claimant to contact ACAS under the Early Conciliation Provisions. These provisions are in the Employment Tribunals Act 1996, Section 18A. And they provide early conciliation form must contain the prospective claimant's name and address and the prospective respondent's name and address. But the legislation doesn't require any further information to be included on the form. Additionally, under Rule 29 of the Employment Tribunal Rules of Procedure 2013, tribunals have a general power to allow a claimant to amend their claim. It's a matter of judicial discretion whether the tribunals use this power. Under Rule 12 of the Tribunal Rules, a claim will be rejected by the tribunal if the name of the respondent on the claim form is not the same as the name of the respondent on the Early Conciliation ACAS certificate, unless the judge considers the claimant made a, quote, minor error and it would not be in the interests of justice to reject the claim, unquote. Finally, Rule 34 of the ET Rules, a tribunal may add any person as a party to proceedings, and that can be on its own initiative or with the application of any party. So, that's the regulatory framework, relevant framework here too. Pausing there. The case of Science Warehouse Limited and Mills is one of the few previous cases where the EAT have looked at the early conciliation procedure, and in that case they held the tribunal could exercise its general power to permit an amendment to a claim under Rule 29, even if this would allow a new claim to be added that had not itself been the subject of early conciliation. When invoking this general power of amendment, case law has set out that a tribunal should take into account, quote, all the circumstances and should balance the injustice and hardship of allowing the amendment against the injustice and hardship of refusing it, unquote. Well, here, Mrs. Miss contacts ACAS to commence a claim against her employer, the Royal Derby Hospital. Following conciliation, a certificate was issued, but the name on the certificate was not the correct name of the respondent. Mrs. Miss then commenced proceedings, submitted an ET1 form to the tribunal, and did correctly spell out her employer's name on the form. Mrs. Miss had brought various claims against the hospital, one of which she believed that she should have transferred under DUPE across to a third-party service provider called Community Health Trust. So her actual employer is the Derby Hospital. She thinks she should have transferred to the Community Health Trust. The Employment Tribunal accepted her claim, despite the discrepancy between the name of the hospital on the certificate and the ET1 form. Following this, hospital submits its defence to the claim. Mrs. Mist subsequently applies to the tribunal to amend her claim to include the Community Health Trust as the second respondent, i.e. to add in the alleged transferee. Of course, at that point, she's not got any potential form, she's not got any form of certification from the Health Trust, or from ACAS, I should say, referencing the Health Trust as a potential respondent. And the tribunal decided to strike out Mrs. Mist's claim against the Health Trust on the basis that she should have included them in her initial ET1 form. She'd no good explanation for failing to do this, and then, therefore, as a result, her claims against them were out of time. So Mr. and Mrs. Mist appeals the decision to the EAT, and the EAT allows the appeal and makes three main findings. First, the EAT held that the paramount consideration when considering an application to amend a claim should have been the relative injustice to each party in granting or refusing the amendment. The tribunal had incorrectly, according to the EAT, focused on the absence of the explanation from Mrs. Mist as to why there was a delay in her applying to include the Community Health Trust on her ET1 form. Tribunal should have focused on the harm instead that would have been caused to Mrs. Mist in refusing the application, i.e., she would have been denied the right to bring her claim in a CHIPI transfer case against the transferee entity. Secondly, the AT held that the tribunal has a discretion to accept a claim despite any discrepancies between the name of the respondent on the early conciliation certificate and that on the ET1. In the EAT's view, the early conciliation process is designed to ensure that ACAS is provided with enough information to be able to make contact with the prospective respondent so there can be an attempt to conciliate, but that's as far as the duty goes. As such, the EAT seems to suggest it would not be in the spirit of the legislation to strike out claims based on prescriptive arguments of form over substance. Finally, the EAT rejected the Community Health Trust's argument that Mrs. Mist should have gone through a separate early conciliation process in respect of her claim against them before applying to amend her claim form. The EAT were clear there was no requirement for her to do this, and that the tribunal had the power to consider the amendment to her existing claim without having to undertake an additional early conciliation process. Well, this case seems to follow in the steps of the earlier case of Science Warehouse Limited and Mills, which I mentioned a minute or two ago, in that, as here, the EAT took a relatively flexible approach when it comes to the early conciliation process. The EAT was willing to accept a claim, despite the respondent's name on the ACAS certificate being different to that on the ET1 form, and they also allowed the claimant to amend her claim to include an additional respondent without having to comply with further EC requirements. I think this decision reflects the claimant-friendly approach to the tribunal, and in particular shows that they don't see the early conciliation process as setting out formal steps which need completing in every circumstance. Rather, it's maybe more of a fluid framework for claimants to try and conciliate claims outside of the tribunal. That being said, the early conciliation procedure is still a relatively new one, so it's not clear how flexible the tribunals will be in their approach to the rules. As such, if you're in the situation where you're facing a claim acting for employer, it may still be worthwhile for employers to run procedural arguments as a defence to any such claim, until this area of the law is clearer. The other point to make is it is remarkable how willing the tribunals are to add in claims against respondents who are only being joined to the litigation for the first time when they're already out of time. There seems to be a very clear difference in approach. If you seek to commence a tribunal claim for the first time and bring it against a respondent, then the tribunals set the bar quite high to permit an out-of-time claim to be commenced. However, if a claim is commenced, but then you wish to add new claims and against new respondents, the bar is set much lower, since in almost all cases the prejudice to the claimant of not being allowed to proceed will outweigh the prejudice to the respondent and being denied the right to have a claim heard in time. However, this dichotomy is not new. In a case like this, it's particularly stark. So, that's the case of Mist and Derby Community Health Services NHS Trust. So it only remains for me to say thank you very much indeed for listening, as always, and look forward to catching up with people in 2 weeks' time. For those of you who were following the first season of Serial but haven't stayed in touch with the second season, well, the second season is very good, but they are doing some updates on season 1 because there is a motion for a fresh trial in relation to the criminal conviction that is the subject of season 1, and it's fascinating. So if you want an update on what happens after the end of season 1, get in touch with the Serial podcast and start listening again. And the other thing is, I've finally got to the end of Making a Murderer, the Netflix series that everyone's talking about. It's really good, very, very interesting. It is worth reading some of the stuff online about it as well, because there's quite a lot of additional material that didn't make its way into the TV programme. So, without further ado, thank you very much indeed for listening. Take care and speak in 2 weeks' time. Bye.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments or want to know how to claim CPD points, please email Nick at nrobertson@mayorbrown.com. Our podcasts are an overview of the cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thanks for listening.